Dictation for Punjab and Haryana High Court and Chandigarh High Court at the rate 80 to 100 word per minute. Be ready? Start. In the circumstances we are inclined to set aside, and we accordingly set aside the direction of the learned single judge contained in the para 4 of the impugned order dated 27/11/2013, calling for the personal presence of the legal remembrancer, principal secretary and the chief secretary for appearance before the court on 12/12/2013. Having said this, it is also necessary to appreciate the anguish which is contained in the order of the learned single judge dated 27/11/2013, which reflects the state of affairs in regard to the manner in which litigation involving the state is conducted before the High Court. The state is undoubtedly the largest litigant. The errors before the court reflect a situation where the state has not taken serious and proactive measures to control and streamline litigation involving the government in the High Court. In order to achieve the goals stated in the national litigation policy, it is necessary for the state government to have a careful and serious look into the question relating to the conduct of litigation on behalf of the state in the High Court and other courts. We are conscious of the fact that such problems cannot be solved overnight and would require a careful and well structured solution. The filing of appeals by the state, the conduct of proceedings in court, making available proper instructions to panel counsel of the government, and the filing of affidavits on time are some of the matters which must engage serious attention on the part of the state government. A system will have to be evolved by which directions of the court in regard to the conduct of the proceedings and for filing affidavits are communicated at the earliest, so that the instructions are made available to standing counsel for filing affidavits. Otherwise, the matters remain pending for an inordinately long period of time, and interim orders which may ultimately affect the interest of the state have to be passed only because of the absence of adequate instructions to the learned standing counsel appearing on behalf of the state. The facilities and infrastructure available for counsel for the state need to be upgraded. We have no doubt that these issues will engage the attention of the state at the highest level, and accordingly we would request the Chief Secretary of the state, with the assistance of the Principal Secretary and other senior officers of the state government, to have a comprehensive analysis made that would facilitate the conduct of litigation by the state in an efficient and time-bound manner. Courts have been liberal in condoning the delay on the part of the state in filing appeals, being conscious of the fact that bureaucratic delays are often involved in the process of decision making. However, we must emphasize that there should be no laxity in compliance of the directions of the court. Once a direction is issued by the court setting a time schedule for filing an affidavit, this direction must be complied with. Full stop.